I welcome each one of you in our last session for MahaSeWA basic registration course. So, of course, throughout this session, we have a lot of speakers who have come, who have given their insights, given their experience, shared their knowledge with all of the participants. I hope you all have enjoyed this whole session. And today, in our final session, we will be completing the whole registration process. We will be completing it with one of the most important topic, that is issues related to the plotted development and related to the closure of project. Because of course, when once the project is started, we do registration, we do the quarterly compliances, we do various other things. But after the project gets completed, closure of project is also very crucial and very important. And today we'll understand on that topic. And today we have with us CA Abhinav Velekar ji and CA Karan Mendirata. They have taken earlier sessions also, and today they have taken time, and I want to welcome both of you all once again in our session. So thank you so much for taking out time. Now throughout this session, I know ki we'll be covering issues related to the plotted development. And of course, during this whole session, if you all have any kind of queries, not just related to this topic, but any other topic, these two experts will definitely take you and make you understand whatever your queries are. With this, Abhinav sir, before we again begin with the session, like always, what does a plotted development mean? If you can just give an idea about what does a plotted development indicate?
First of all, thank you, Shreyas, for giving this opportunity. I would also like to thank Ramesh Prabhu sir for arranging this series for every one of us in understanding the RERA Act, the intricacies that are involved in this. With regarding your question that what is plotted development? Plotted development means when we convert a land into a non-agricultural land and then sell the plotting of that means we convert that complete land into pieces and we sell it to the customer. So that is what we call it as a plotted development.
Yes, Karan, do you want to, give your views regarding plotted development? Like, I understand it's very much similar only, but in terms of once any project is getting developed, registered in terms of a plotted development, what are the things they should keep in mind while, registering themselves as a plotted development?
So majorly the issue was involved with the plotted development before RERA was that the builders, layout developers were actually converting the land into layouts, but they were not handing over the proper plots to the allottees, like the roads, the sewage line, and all the electrification works. They were not done, and the projects were half completed. The projects were NATP. The documentations were not that much completed. So that's why MahaSeWA came in after MahaSeWA came into the picture. Now handing over process has been formed. The whole process system has been regularized. Now plotted developments are since covered in RERA. The documentation works have been stringent now. The advocates are taking due care while giving the search report for the project. So these are the things which happened before and after RERA for plotted development.
Abhinav sir, of course, you have your own, you will be sharing the presentation also, but there is another subtopic on, in today's session, that is a closure of project. Of course, plotted development is a very different, and closure of project is very different. But when do you consider a project to get closed? Like, is it when the completion date in the certificate is done? Does that mean indicate that the project is closed? Or does it indicate that when you get the OC of the project, then it gets closed? When the whole money is transferred, when the bank account is closed, that is when it is considered as closed. What does a closure of project indicate?
Correct. This is very important because actually the problem is that each event that you just spoke of, it is basically a closure of the project. But with respect to MahaRERA, we can say that the project gets closed only when Form 4 is uploaded, and the Form 4 has to be uploaded only and only when the 100% of the amenities, the commitments that the builder has made to its customer has been fulfilled. It doesn't mean that you have received the OC and some part of the project is still pending, like some finishing work is there, which is yet to be done. So you have to wait to get it completed. You have to get it verified from the architect that yes, all the amenities and whatever was committed by the builder has been fulfilled. And now the Form 4 will be issued by the architect, and that once that is uploaded on the RERA website, then we can say that the project is complete. In case of Maharashtra, the project is getting completed at this stage, but the formation of societies can happen thereafter. So that part is still to be looked into whether, but since we are only talking about the Maharashtra as of now, the project gets completed. But the formation of the association, handover of the association is one of the things which is happening after the project is handed over or is completed. So we have to take it into consideration in deciding whether the project is complete or not. So Form 4 plus the handing over of the common areas to the association. These both things, when they get completed, then only we can say that the 100% project is completed with respect to Mahare.
Karan, in this regard, of course, we have understood कि when the form 4 is submitted, that also indicates that the project is closed. Just one important question regarding the closure project. Does the promoter's responsibility gets, is vanished? There is no promoter's responsibility after you submit the form 4? Or is there still promoter's responsibility in terms of the project after the project is closed, handover is done, conveyance is done, everything is done? Let's assume everything is done. Is the still promoter liable for any kind of thing?
There are many issues which I have write it on in my presentation, in which I'll be covering that even completing the OC will not suffice the closure of the project. And closure of the project is not when the form 4 is accepted. It is, there are many other things also, that the bank account has to be closed, and there are parallelly all other things are there. Avinash sir rightly said all the points which are there in project closure. But my personal is like, when I'll be sharing the PPT, I'll try my best to tell you how the project is closed through the act.
Definitely.
Because that is the major objective, because the act is the only thing. Discuss this, but because responding to the question which you have asked, in a short line, section 14 is there, which covers the adherence to sanction plan. There is section 14, subsection 3, in which the structural defect is 5 years. So the builder, even though getting the OC, will be having held liable for the next 5 years until and unless the structural defect period expires. So this
Okay.
is one also there.
Def-
Rest all I'll discuss in the later.
No problem. I think so. We have gotten a broad understanding about, what the plotted development is regarding closure also. Again, these two are completely different topics, I understand. But we'll begin with the session today. Abhinav sir, I'll request you to, share your screen, share your PPT, and give your insight regarding the plotted development as well as closure of project. And then we can take up. And if in case, again, there are few questions which are asked. I think so that during the session when that slide will be covered, I think so it will be answered. Abhinav sir, with this I hand over the mic to you. You can take over.
Sure.
I'd like to thank all the participants who have been part of this whole sessions. The Mahara Basic Course group, which is still active, the paid group as well as the non-paid group, they both will remain active. And if in case any kind of queries you all have, regarding whatever kind of queries regarding RERA is there, regarding RERA, this topic is there, you all can definitely ask us in that group. And all the experts, all the speakers who have been, have been taking the sessions, they are part of this group. So they will be more than happy to answer all your queries.
So we will start with today's session. So I'm basically covering the plottable layout project registration. So when we see the total life cycle of the project, it starts from the registration. We have to, once we have to, it is decided that we want to sell the project to the outside parties. Then the requirement of the registration is there, which we have to comply as per section 3. Then comes section 4, which specifies how the application for the real estate project has to be made on the website. Then this registration is granted to us under section 5. And if there is any requirement of extension or certain things we should know before registering the project. So the basic things, the major 3 definitions that are very important to know before going into the registration aspect are: one is the real estate project. What do we mean by the real estate project? Then who are the promoters who have to register under the RERA? And what is the planning area? So we have to understand these 3 basic definitions before moving to the registration part. So the important question many times the people ask is like whether we have to register the plottable projects. We have to register the plottable projects because this question arises because the limit is of just 500 square meter. What the RERA says is that if the plottable area is more than 500 square meter, then you have to register the project. So this question always arises that whether the plottable project also comes under the purview of the RERA. So to find out this answer, these definitions that I just talked about are very important. So as for section 2, the real estate project, what does it consist of? It consists of the development of a building consisting of apartment, converting an existing building or part thereof into apartment, development of land into plots or apartments. So if you can see at point number D, it clearly says that the real estate project will have the development of land into projects. So this aspect of definition covers the plottable project. And all the above four things has to be for the purpose of selling all or some of the said apartments or plots or building as the case may be. So if you are having a plotted development project, and if the promoter intends to sell it some or all of the inventory, then in such cases such projects has to be will come under the definition of real estate project. So the definition is further expanded, but since we are basically dealing into the plottable layout project, so we can see that the plotting is coming under this definition. Second, the many aspects of this definition are separately covered in the Act, like the apartment has been defined, building, immovable property, everything is defined under this Act. We will not go into the detail of this because our topic is related to plotted development. So we have seen that the real estate project covers the plottable development. Now the second question comes whether under the promoter, the selling of the plots is also covered. So we will now cover the definition of promoter. Here you can see that the first part of it talks about a person who construct or causes to be constructed. So it's talking basically of construction of shops, buildings, apartments, flats, whatever you call. So if there is any kind of construction, that will get covered under the RERA. But if you see the second part of it, the point number 2, it says that a person who develops the land into a project, whether or not the person also constructs structure or any of the plots for the purpose of selling to other persons. So what it is talking about is that when you are launching any plottable layout, such projects will also get covered, whether you are having a structure thereon or not. So if you are just selling the plots, then also it will be covered. Suppose you are you are selling a plottable layout, but you are converting it into a row houses layout. So that too will get covered in this definition. So this second part again covers that the plottable layout will be covered under the definition of promoter. There are other parts of these definitions, like point number 3 says that any development authority, like so if any MADA launches any product, the authority also has to get it registered, whether they are executing any building or apartment projects or they are executing any plotted development project. So such government authorities also has to get themselves registered under the Act, since they are coming under the definition of the promoter. So here at point number B, it specifies that the plots owned by such authority or body or placed at their disposal by the government also will come under the definition of promoter. And the last point of it also says that any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by any other name, or claims to be acting as a holder of a power of attorney from the owner of the land on which the building or apartment is constructed or plot is developed for sale. So clearly it can be said that in the case of the real estate project and in the case of the promoter, the plottable layout will get covered. Now the third definition which is important with respect to this is the planning area, because the Act says that the RERA is applicable only in the planning area. So in the case of Maharashtra, the complete Maharashtra area gets covered under the planning area because that is defined under the MRTP Act. So there is no question whether any part will get excluded from this definition. There are some states, like in the case of Gujarat, they have specifically defined what is planning area. So there some parts get excluded and some part gets covered. But in the case of Maharashtra, 100% Maharashtra get covered under the definition of planning area. Now, when we move from all these basic definition to the basic means section 3, which defines which project and when it has to be registered, again we can see from this definition that plottable area is covered. How? We will just check. So section 3(1) says that no promoter shall advertise, market, book, sell, offer for sale or invite any person to purchase in any manner. Means कि कोई भी प्रमोटर जब तक एडवर्टाइज अगर उसको करना है या मार्केट करना है, बुक करना है या सेल या ऑफर फॉर सेल करना है या किसी पर्सन को इनवाइट भी करना है अंडर दिस 3(1) फॉर व्हाट? फॉर एनी प्लॉट, अपार्टमेंट और बिल्डिंग एज द केस में बी in any real estate project or part of it in any planning area without registering the real estate project with the real estate authority. So section 3(1) says that कि कोई भी promoter एडवर्टाइज नहीं कर सकता, मार्केट नहीं कर सकता, बुकिंग नहीं ले सकता, सेल या ऑफर फॉर सेल नहीं कर सकता. कब तक? जब तक he gets his project registered with the real estate authority. So again, section 3(1) is very clear that the plottable layout project will come under the registration of the RERA. Then the first proviso says that the project that are ongoing and the date of commencement of the act for which completion certificate has not been issued to be registered within 3 months. So all the projects which were not completed or which had not received OC at the time when the act came, they all had to be registered with the RERA. Then the second proviso says that the authority can ask to register the project in the interest of the allottee for project beyond planning authority with the permission of the local authority. So this situation doesn't arises in Maharashtra, as I had already told you that the complete Maharashtra comes under the planning authority. Section 3(2)(a) specifies the exemptions, which are the exemptions that was granted by the act. आप लोगों को ये समझना चाहिए कि ये जो एक्ट है, it has been formulated or has been passed by the central government ने पास किया हुआ है, and it is implemented by the state government. So what has been specified in the act or the act which has been passed, it is passed by the central government. So what are the exemption that the central government has given? So section 3(2)(a) specifies that where the area of land proposed to be developed does not exceed 500 square meter, or the number of apartment proposed to be developed does not exceed 8 inclusive of all phases. So suppose your project is you are launching it in multiple phases. So adding all such phases, then the total units should not exceed 8. If it is like you are launching like you are launching a building in which there are only 4 flats, then you are in the second phase you are again going to launch another 5 or 6 flats. Then in such cases you have to take the total of the 2 phases, and if it's going beyond it, then this condition has to be applied in that manner. With respect to the exemption part, we will get it a little bit clearer once the circular number 2525A comes. So basically the act says that when either of these two conditions are satisfied, the project is exempt. Section 3(2)(a) says that the government can reduce the limits, but it cannot means increase the limit. So there is a restriction on the state government. So we have to keep this in mind always. Why I am saying so? When we go to circular 2525A, we will interpret this there, where the promoter has received completion certificate at the time of commencement of the act. So this exemption only covers the project which were completed at the time when RERA was launched or RERA started. So if we are receiving the completion certificate after the RERA came in, first we have to get that project registered, and then once the completion certificate gets, we have to upload it and get it cleared from the RERA with vis-a-vis form 4. So this was the exemptions that was given under the act. Then section 3(2)(c) specified that if there is some redevelopment project where there is renovation and repair and there is no sale to the outside party, such projects, such redevelopment projects were also exempted. So as just I told you, like section 3 specifies that the plottable will come, and it specifies only 3 conditions where the project will be exempt. Like if the project area is less than 500 square meter, or the total number of apartment units, flats are less than 8, or when the project has already received the OC before the launch of the RERA, or if it was of the redevelopment and there wasn't any sale to the outside party. All such projects were exempted. Now, the regulation 3B of the Act specifies what we called it as it modified certain things, because till this regulation came in, it was like we had to always take into the consideration all the format which were basically made for the building purpose, and we were not allowed to change the format because many of the things were not applicable to the plottable projects. However, this regulation made the changes, and it then allowed all the professional to make appropriate changes in all the form. So the first point that this regulation cover with vis-a-vis the plottable layouts are, first is that form 1, 2, 2A, 3 and 4 can be wherever the section requires, and wherever there is a requirement that it has to be made in properly suitable for the plottable project. Such changes can be made by the professionals, like form 1 is issued by the architect, so he can make that changes and he can issue that form. Second, this regulation also specified the model form of agreement. Before this date, there was no model form for plotted development, But when this regulation came, now we have a model form of agreement for the plotted development, and we have to prepare the agreement to sell format on the basis of this model form. Then it also clarified that in the case of the plotted development, if building plan is not available, then NA order will suffice, and that will be considered as the building permit or the commencement certificate. Uh, and what will be termed as the occupation or completion certificate? In this, under this regulation, it was said that suppose if under the local laws there isn't any provision for completion of the project for the plottable projects, then in such cases architect can issue form 4 and he can certify that the project is complete, but only where the local laws doesn't have this system of issuing completion certificate. So all these changes were brought in on 6th of June 2019 by the regulation. Then again on this same date the rules were changed, and rules also incorporated many changes with regarding the plottable projects. Like it defined what do you mean by the plottable development. So it said that the plottable development means the project where land is developed into plots for the purpose of selling all or some of the said plots. This particular amendment into the rules also revised the total fee structure. Now the fee structure for the plottable development is minimum 10,000 rupees, and the rate is 5 rupees per square meter on the basis of the plottable area. Now, when we were talking about the section 3, I just told you about that exemption circular. Though exemption circular talked always about the 500 square meter or 8 apartments, when the department came with the suggestive answers for the questions that were raised to them, and they had issued the FAQ, what they interpreted with regarding this exemption circular was that either of if you the condition is satisfied, then you have to register the project. However, this condition was changed when the case was moved by the Gitanjali apartment owners, and there the appellate authority held that no, in the case of the interpretation of this definition, we have to fulfill both the conditions. So thereafter, circular number 25, a clarification was also issued, and so now the situation is that when both the condition like 500 square meter and the units are more than it, then only we have to register the project with the RERA authority. This change came with a condition that this case is now has been filed in the High Court. So if the Honorable High Court give a judgment with regarding this case, so all the registration will come vis-a-vis has to follow whatever is the judgment of the High Court. But till that time, the situation that is there is that no project has to be registered if any one of the condition is registered. Then in this circular, a very important thing has been specified with regarding the plottable project. What it says is that if the promoter has received CC or OC or NA in case of plotted development from competent authority, any time before agreement for sale or sale deed registration, then such projects are also exempted. As we have seen the proviso of the sections, there it has been specified that only 3 conditions were there which specified the exemption. And we also talked about a situation where the central government has restricted the state government by giving the additional benefit with vis-a-vis exemptions. But however, Maharashtra government or the MahaRERA authority had came up with this, and here they have specified that if you have you are receiving the CC and up to the date of CC or OC, you haven't sold any of your units and haven't executed any agreement for sale or sale deed, then in such cases, such projects will get exempted. And for the plotted development, they said if you receive a NA order, then that project will also get exempted. But since it is overruling the section 3 exemptions, in my opinion, this does not hold good, and we should always register all the kind of projects that are there, like the plotted or the development projects. Then that further clarified with regarding the redevelopment projects that were there. So section 3 circular 25 and 25A are very important for assessing whether a project is to be registered with the RERA or not, including the plottable layout projects. So in this case, we have to keep in mind that there are different or there are n number of sanctioning authorities which are specified under the UDCPR. It is the Unified Development Control and Promotion Regulation, which is there in the Maharashtra, which is applicable to whole of Maharashtra except Mumbai region or the MMR region. So under this, they have specified the sanctioning authority. So if your land is coming under the municipal corporation, then municipal commissioner will give you the sanction. If it is coming under Zilla Parishad, then it is the chief executive officer. If it is a municipal council, then the chief officer of the council will give you the sanction. In likewise, if suppose it is coming under the regional plan, then the collector of the district in which the land is coming will give you the sanctioning for that. And suppose it is coming under the Development Authorities Act, then the Metropolitan Commissioner of MMRD or the NMRD or any other authority which is constituted under this act will give you the sanctioning. No sanctioning from like the Gram Panchayat or any lesser authority will have that authority of sanctioning the project, and neither will the RERA accept that and will give you the registration of such projects. So then, as we talked about, Section 3 specified which are the project which has to be registered. Section 4 talks about what is the manner in which or what are the forms or the documents that are going to be required for getting our project registered with the MahaRERA. So we will have to have like approvals and commencement certificate, building permit will be required, sanctioned layout plan will be required, the development plans will be required, the location of the projects. Then as we have just seen under the regulation 3B, the pro forma of allotment letter, agreement to sell has to be uploaded at the time of registration. Form B has to be uploaded. Then the area of the individual plots that we have to sell, that has to be uploaded. And all such finer details have to be uploaded at the time of registration. Then the declaration has to be given of that is the Form B. And what we give into the declaration, what the promoter signs is that the legality of the title of land. He specifies that whether the land is free or there is any kind of encumbrance, what will be the timeline for the completion of the projects. He give a declaration to the authority and to all the customers that 70% of the amount that he is going to receive from the sale of the units will be deposited in a scheduled bank to cover the cost of construction and land cost, that is into the RERA designated bank account. That he will take any pending approvals, if there are, all such pending approvals will be taken by him before handing over the complete project to the Association of Allottees, and furnishing all and every such other document which has to be there for completing the project. So once this is the procedural aspect, like once we apply and once all the forms are uploaded, either the authority will grant you the registration or they will reject it. The RERA Act specifies that once we make the application within 30 days, the application has to be granted the registration or it has to be rejected. If beyond 30 days the application goes, then it is a deemed registration that the authority gives us. But however, in the case of Maharashtra, normally what happens is that once we give the application, if there is any query, so from the date of query, the date will be calculated. And that will be like from the date of query, once you again resubmit, the 30-day period will get start. So it won't be the first date of submission, it will be the resubmission date. And again, if within 30 days it doesn't happen, then you can get the benefit of this section. Under section 5(1)(b), the authority also has the powers to reject your application. However, in this case, they first have to give you in writing the reasons for this, and also an opportunity of being heard has to be given by the authority to you. I just talked about with regarding the deemed registration, like if within 30 days the authority doesn't grant you, so deemed registration will be processed in your favor, and you will also get the login ID and password for the same. And what is the validity of the registration? Whatever period that you have specified, that is the completion date that you have specified in your project, will be the validity of the registration. How the plotted development projects get completed? Now for this, there is an order that was issued, and what is talked about is like just we saw in the circular number 25, they have specified that any order will be considered as the completion certificate. However, in this order, they have again gone back and they have said that any order will be treated as a commencement certificate. Now they came to know there that some mistake was made while issuing that circular, and so then they clarified this, that the commencement certificate will means any order with sanad issued in either schedule 4 or 5 in accordance with rule 4 and 7 of the Maharashtra Land Revenue Act. In the same way, what do you mean by the completion certificate? So it means any receipt of Tahsildar that all the conditions that are there has been specified in the NA order has been met as per rule 11A. So if this order has been issued by the Tahsildar, then after receiving this, the promoter has to go to the architect, get form 4 from him that yes, OC has been received from the authority, that is the Tahsildar. But suppose there are certain things which are in addition to what has been committed by the promoter, then if all such things are also satisfied or has been developed and has to be delivered, and if everything is ready, then only the architect has to issue the form 4, which will be uploaded on the RERA website, and the project will get completed. Now the question arises whether if there are anything like if the handover is pending, like of the common amenities to the association of allottees, then it can under the MahaRERA as of now, the completion will happen, and that part can be looked into afterwards also. But for the MahaRERA, project will get complete once the form 4 is issued. But in some state that doesn't happen. Like recently in the case of Odisha, they have said that till the time the association is allotted everything, till that time the project will not be considered as complete. So it is state wise, because the state government has certain authorities, since they are the implementing agency, and they can differ in certain sections of the rules regarding that. But with regarding the act, where the act very clearly says that the exhibition cannot be touched with, no state government can lower the limit. Like in the case of West Bengal, I should say, highlight to you all that they have lowered the limit, because that is granted by the act. So they have lowered the limit. There the requirement is not of 500 or 8 units. I think there the requirement is of 200 or 250 square meter. So the state government has that authority to that extent. One more thing that I wanted to talk about with regarding the plottable area registration, there is one judgment that has came from the authority. It says that if you are launching an industrial unit, all such industrial units are outside the purview of the real estate project. However, you should be cautious while analyzing this judgment, because it talks about industrial units and not about industrial plots. So what they mean by industrial unit has not been specified in this judgment. And so we have to take this judgment with a pinch of salt, and accordingly we should act. But there is this judgment with regarding the plottable area, like the industrial units are exempt otherwise, if you go by this judgment. So thank you everyone for giving this opportunity.
There is one question which has been asked. It was asked earlier only. What type of society should be registered in a plotted development? Under like if a society is going, will it be covered under plotted development or not?
Yes, you can register the society under the Society Registration Act, but there is now an anomaly that is created. Like in our region, I come from Nagpur. Here, what happens is that all the common amenities gets handed over to the government of Maharashtra. So when we launch a plottable project, when the NA order get passed, then the plottable layout and Satbara gets created. But the Satbara of the road area, the open space get created in the name of the government of Maharashtra. So
Yes.
as such, the authority is not with the promoter once the NA order is passed. That has already moved to the government of Maharashtra. But the RERA Act says that we have to hand over the open spaces and the roads or other amenities to the association. So there is the dichotomy that is there in the Act. But as of now, we can form an association and can hand over to the association for the requirement of the RERA. But on the ownership point of view, that is already handed over by the collector or by the commissioner to the government of Maharashtra. So legality will always be there with the government of Maharashtra as of now, but you can hand over for the purpose of RERA, the association, the complete responsibility of that layout. Also here one question arises, like the maintenance of such layouts is handed over to the local Gram Panchayat or the suppose it is coming in NMRDA or the MMRDA. If they are having a maintenance association, it is also handed over to them. So what is happening in your local areas, we have to check it out every time.
Yes, I think so. You have answered the query. And of course, in the meantime, if any other participants also has queries, you all can ask us in the chat box. Abhinav sir has taken us to hold the plotted development and the closure of the project also. See, now even Karan sir will also, take you through the whole thing. But it will be like a revision kind of thing. And of course, if in case Abhinav sir has missed out something, Karan will always, cover that also. So Karan, over to you. You can share your screen.
So my topic for the today's session is closure of project. Avinash sir has already covered completion and almost completion stages. but I'll be trying my best to give you an overview on how the closure will be of the project, and as a consultant point of view, what you should communicate to the client for the closure of project, because many of the clients are not aware and you are the only person they will be asking. So that's why I'll start with my slides. So the what chapter 3 of RERA Act, we already are aware of it and we have covered in the previous sessions also. I'll just have a review of these sections because chapter 3 covers the promoter liability and responsibility. So the project, or I'll say the promoter liability, will be covered when these sections are fulfilled by the promoter. So these are the basic 8 sections which every consultant must be aware. I would say written down on your minds, because these sections are very practical. And I'll just have give you overview of the section 11 is the basic functions and duties which we have covered in the previous, and section 12 is regarding advertisement, section 13 is regarding deposits, and section 14 is regarding sanction plans, section 15 is regarding if in case the promoter is transferred to another promoter, section 16 is regarding the insurance. Title insurance is not yet came in India, but it is there because in the future it will be coming. Section 17 is regarding transfer of title, and section 18. So I'll be covering typically 3 sections in this particular place of closure of project for this topic. That is section 11, section 14, and section 17. Why I am saying about these 3 sections? Because these 3 sections gives the timelines and few of the responsibilities of promoter which has to be fulfilled before the project is getting closed. So I'll first start with section 11, that is functions and duties of promoter. In this section, the section covers it very well, that what is going to happen if once the project is registered. What I want you to understand that the particular subsection 1 of this section, he says that the promoter has to fulfill all the details like quarterly up-to-date list of number of apartments, quarterly up-to-date list of number of garages, quarterly up-to-date list of approvals if he is taking, quarterly update status of the project. So these are what the subsection 1 is trying to say is that the promoter has to complete all the quarterly progress report of the project. So if a client is coming to you and he's saying that my 2 years have been completed and the project is almost completed, I have received the OC but I have not done the quarterly compliances. So you have to guide him that even though the form 4 is can be uploaded or you can get the acceptance, but still the quarterly compliances obligation is on the promoter and he has to fulfill that even though he's doing at the later stage also. So this is the particular section that I have covered in this, that if for handing over the things of closure, this quarterly update is the first step you have to complete for a real estate registered project. Then there are other things in the particular section, like how the advertisements will be there, how the booking, but subsection is the main concern which I wanted to discuss on this particular topic. Then I'll come directly to one section. So sequence is like section 11, 14 and 17, but I've rearranged the sequence with section 11, 17 and 14, and I'll tell you also why in the upcoming slide. After section 11, I have covered section 17, that is transfer of title. So transfer of title is basically what is the timeline given to the promoter for transferring the title of the project. So if we have received the OC, the builder has received the OC. So is it okay if he has an allotee in his who has booked the apartment in his project, but still he is not executing the sale deed and the allotee is going a RERA complaint. So as a section 17, he's been obliged to transfer the sale deed once he have received the OC within 3 months and hand over the society to the associations after the completion certificate of 1 month. So there has been amendment in this section also in after the RERA Act came. That is also I will discuss in this slide. The main purpose of the section 17 is to create a timeline for the builder to execute sale deed. So the builder now, after this section came into the picture, he cannot make the sale deed delayed. He cannot make the transfer of possession delayed to the allotee. So I'll just read out this section that because it's a very important section. That section 17(1), that is conveyance, is promoter shall execute a registered conveyance in favor of allotee along with the undivided proportionate share as the case may be, and hand over the physical possession of the plot, apartment of the building as the case may be, to the allotee and the common areas to the association of allotee as the case may be in the real estate project and other title documents. Provided in the absence of any local law, conveyance deed in favor of allotee or the association of allotee, the competent authority as the case may be, under this section shall be carried out by promoter within 3 months from the date of issue of occupancy certificate. So if there is a local law like Apartment of Association Act or MOFA, then we will prevail the timeline there what is given. But otherwise, you have to follow the, if it is not there, then we have to follow this particular 3 months of there. As per MOFA, I believe it is 3 months only, but Avinash sir can tell the exact, Avinash sir or Shreyas can tell the exact, but you can guide the promoter that the 3 months has to be within 3 months of receiving the OC. He has to make sure that the sale deed of his allottees are completed as per this section. Otherwise, the allottee will take the benefit of section 18 and will start charging the interest.
MOFA, it is 4 months. So because there is a local law which is pertaining, so you get the
4 months.
Yeah, you get the leverage of 4 months, maximum 4 months.
So that is there. And subsection 2 is basically handing over the plans, sanctions, and physical possession of the common areas, necessary documents relating to the project to the association, and it will be 30 days, that is 1 month from the date of receiving completion certificate. So completion certificate is mostly used in plotted developments. You can treat as an occupancy certificate for the buildings. There are cases when part OC is given, full OC is given. So when you will receive the full OC, the completion certificate will be treated as OC. So in the cases of part OC, the full OC of the whole project will be treated as completion certificate. At that time, you have to make sure that within 1 month, the documents have been transferred. These are the obligations which are there in the act. So when we talk about closure of project, these are the obligations which has to be communicated to the promoter, because once the obligations are completed, then the closure will happen. Then the handover and the responsibility of promoter will be completed. So this is there. Section 14. Now why I have came section 14 afterwards, after to section 17 is reason behind is section 14 deal with the defective period, which I have discussed in the first session of when I was discussing with Shreyas. That section 14 I'll be speaking subsection 3 in this session, that is structural defect period. This section has clearly said that in case any structural defect happens as per the agreement for said relating to such development is brought to the notice of promoter within a period of 5 years by the allotee from the date of handing over the possession, it shall be duty of the promoter to rectify such defects without further charge. So the time period of 5 years will start when subsection 17 subsection 2 will end. So at the time of handing over the, suppose if in case I have received the OC today, that is 29th of I've received the OC today, that is 5th September 2024, and I have transferred all my obligations of handing over the society on 5th October 2024, then the 5 years will start from the 5th October 2024. If I have transferred all the documents of handing over the society on 30th September 2024, then the 5 years will start from the 30th September, not from the 5th October. So these are the things which you have to keep in mind while closure of project. So there is one form which have to be submitted for closure of project. Quarterly update has to be completed. I will not be covering quarterly update because it is already covered in other classes over. So closure of project forms to submit. There is one form which is a completion of project architect form. Architect is a whole soul person who will tell to the authorities that the project is completed on the basis of government document which he will receive, that is occupancy certificate from the local authority or completion certificate from the local authority. The certificate, if you see the format of form 4, I'm not just shared in the this slide, but format of form 4, it is given that please give the reference of the local authority order which you are giving, on the basis of which you are giving the completion certificate. So this is a new MahaSeWA website web page in which I have shown you that form 4 is, we have to submit form 4. They have given us the different tab for submitting form 4. Previously it was in the documents upload section, but now the particular tab has been came now, and I believe the process of getting acceptance may change, but in times to come we will let to know understand, because on first only the site has been come available. So once you upload the form 4 in the web page and you have completed the completion certificate, with form 4 you have to submit the occupancy certificate of local authority to the MahaSeWA website, or if in case of plotted you have to submit the completion drawings also. If it is there in Nagpur, we get the completion drawings of the layout, so you can submit those drawings also in the completion of project format. Once these are done, you will receive a mail of form 4 acceptance. This is a mail of form 4 acceptance we usually get once we submit the form 4 in the MahaSeWA website. In next, after Mahakriti, maybe the internal process must have been changed, or maybe this process will follow. We'll let to know, but these are the automatic mails which we get from the MahaSeWA. Once you receive this form for acceptance, that means your project is completed in MahaSeWA website, but that is not a closure of project. That is completion of RERA MahaSeWA web page process. So there are a few points which I have noted down. Once this particular mail you have received, what are the things you have to keep in mind or you have to communicate to the promoter? First, that is form 4. Once you have received, you have to make sure that the promoter is closing his RERA designated account 1, 2, and 3 on the base. You have to just give this mail to the banker, and the banker will close all the 1, 2, 3 accounts of that particular project. That has to be followed. Second, you have to communicate to the promoter that the structural defect period has been started now. So make sure that the project, that his responsibility of 5 years is now have started. So if you see that in RERA, you give a timeline of 3 years, 5 years for completing the project. Once that project timeline is completed, the structural defect period starts from there. And the last thing is time limit of section 17, which I've clearly said that conveyance in case of MOFA and other related local laws, handover process will be initiated, and particularly 3 months and 1 month in case of handing over the possession of common areas to the allottees and transferring of conveyance deed to the allottees for possession of plot, land, or apartment. This time limit will be bound by him. So you have to make sure that once you have received the completion certificate, all the bookings of his apartments are getting safely done from his side within 1 month, within 3 or 4 months as per MOFA. So these are the few points which I have covered for closure of project. There are few scenarios which I have noted down, and I wanted that these are the common cases which we get in our practice areas, and the promoters ask, that is what case one, if we have not complied any compliances from past 2 years and we have completed the building, can we submit form 4? And if it is accepted by the authority, are we free from our obligation? So that is I have covered. Even though your form 4 is accepted, you have not completed any compliances, you are bound to complete the compliances. It is as per act, you are bound to update all the quarterly updates. So form 4 acceptance will not I'll say free the promoter from his obligations. He can get the penalties of non-compliances from the our respected Sanjay Deshmukh sir for the project. In case 2, when if the project is kept in abeyance by the authorities, however our project now is completed, can we submit form 4? So this is also the major issues which we get in our practice. Once the project is in abeyance, you cannot submit any form 4 because the quarterly compliances or the documents upload section is blocked by the department. First, you have to make sure that all the compliances and all the statutory compliances are done by the promoter, and the project is live again in the MahaSeWA web page. Then you can submit the form 4, and you can get the form 4 acceptance mail. And the last questions which we get, that is how can we check whether our form 4 is accepted by the promoter? So many of the times, previously we were not getting any form 4 acceptance mail. Now in last 1 year, MahaSeWA started giving the form 4 acceptance mail. So major questions which we get is how can we check whether it is accepted or not? So the best answer I can give you for this is, there may be chances that the mail you may be not be receiving any mail. You can resubmit the form 4 and get the mail, or else if you can check if for particular 1 month the form 4 is live on the MahaSeWA web page and it is visible to the allottee without login, then your form 4 is accepted. We have tried to mail the authorities, but they says that you have to resubmit the form 4. But if it is there for 1 month and form 4 is not removed by the authorities, then it is actually been accepted by the authorities. So that can be deemed accepted. You can tell the banker that it is available on the MahaSeWA web page. He can check it from there and he can close the MahaSeWA designated accounts also.
Yes, I think so. Karan, you have covered much more than what was there, but I think you have given a detailed and extremely detailed explanation of everything. Just one question. Like you mentioned, if suppose for some reason I got the form 4, I got the completion certificate, I have it, but I have not yet filed the form 4. For example, 2 quarters have been done. I have not filed the QPR, like you mentioned, in case 1 only. It has not been filed for 2 QPRs, but my completion certificate is there. I have, everything is done. Should I still have to file the QPR even if it's 100% complete for both the quarters?
So QPR is basically the section 11 subsection 1 responsibilities. Even though you are uploading the form 4, but I'll personally say that the department has the whole full-fledged power that they can give you a penalty notice for non-compliance of QPR. QPR is, see, the question you have asked, I'll compare it with GST. You are saying, I have not filed GST R1 and 3B, but now I have filed GST R9. So my responsibilities of R1 and 3B are done. That's not going to happen. So QPR is a mandatory document you have to submit. Even though you have received the form 4, you have completed the form 4 completions, but you have to make sure that all the quarterly updates in the MahaSeWA webpage has been done. It will affect your credit rating also in future if you are a promoter. And now MahaSeWA have come up with a new website. Mostly, what I believe is in the future years, all promoters who will be there having their IDs, they'll be getting the credit rating from the MahaSeWA and that will be visible. So it will affect the MahaSeWA credit rating also because it is one of the parameter in measuring the credit rating. So we cannot guide our client that QPR, you are free from all the QPR obligations. He has to make sure that it is done.
Yes. Abhinav sir, I think so before we end the session, one query to you. Again, I think Karan has already covered it, but if in case, supposingly, I have done my form 4 filing has been done, everything is done. I got the acceptance letter also, but there are still some funds, pending with the bank. Then what is the process regarding that? Do we approach the bank with a form 4 certificate? Do we go with the mail which is there? And how do we end the project? Like when do we get free from RERA is what my question is.
So yes, once the form 4 is issued, it is uploaded and the mail is received. All such communication has to be given to the self-declaration has to be given by the promoter to the bank, on the basis of which the funds that are there gets means released by the bank. As of now in Maharashtra, now every state is having some other way of doing it. But in the case of Maharashtra, once we get the form 4, the acceptance mail from the MahaSeWA, both the things will suffice and the funds will get released from the bank account. So that will suffice the total requirement as of now.
Okay. I think so perfectly we have covered both the topics, which is the plotted development as well as the closure project by both the speakers. And of course, with this, I will formally, end today's session and just want to say thank you to each and every participant who has been there from the start, as well as I want to thank each and every speaker who has been part of this session, right from day 1 till today, the day 14th lecture is there. We have combined few sessions. We had a lot of question answer sessions. There were some delays also which were there, but today I want to say a thank you to each and every one of you once again for being participant. We will keep on having these kind of sessions continuously now, because one more topic which we are planning to do is about the Mahakriti new website which is there, because we have been observing, be it new CA, be it new professional, as well as the most experienced one, it is a completely new domain for each one. There are a lot of problems. Even if you file a QPR, there are some server issues, technical issue, because of it the server is crashing, registration is getting complicated. So in the coming days, coming weeks, we'll definitely cover that. Once again, a vote of thanks to Karan, who has again taken out time from his busy schedule and explained us through the whole closure of project, and is always available. If in case you all have any queries, you can definitely ask him. He's there in the part of the group also. And I also want to thank CA Abhinav Velekar sir. Again, I think the second or third session he was part of our this whole lecture, and now again he has come at the closure of this seminar. So thank you, sir, for again taking out time and guiding the whole participants, because there are a lot of new freshers also, and of course this is there on our YouTube channel also. So because all the 14 lectures, it will be available on our YouTube channel. If in case you all have missed out any, you can definitely take a look at the playlist which is there on a MahaSeWA YouTube channel, and it will be really helpful for you as well as all the new people also who are willing to go into the RERA practice. And like I again said in the beginning, the WhatsApp group which is there, which has been created, it will always be available, wherein all the experts are present, as well as if in case you all have any queries or any doubts, you all can definitely ask us there. All the experts will be more than happy to answer them. So with this, I thank you once again everyone for joining in.
Yeah.
Thank you,
Thank you,
Shreyas.
thank you, Shreyas.